Welcome to Heseltine Law's informational series of videos on estate planning titled Meaningful Estate Planning. Heseltine Law is a law firm in Palm Desert, California, focused exclusively on estate planning. Our comprehensive estate planning services for clients include, but are not limited to, revocable living trusts, irrevocable trusts for estate planning and beneficiary planning purposes, pour-over wills, advanced healthcare directives, powers of attorney, guardianship provisions for minor children, and charitable planning. As a service to the community, we are producing videos on important estate planning issues and frequently asked questions. If you are a California resident and have questions, would like to attend one of our complimentary estate planning seminars in Palm Desert, or would like a free consultation with an attorney, please call us at 760-777-0496. You may also reach us at www.heseltinelaw.com. In our last video, we examined the dangers of doing nothing as an estate planning decision. So let's take a look at what happens if we put things in joint tenancy as an estate planning method. If we title our assets in joint tenancy or in community property with rights of survivorship, then we have this opportunity for the property to just pass immediately from one person to the other. That does not necessarily solve all of our problems, however. We still have the potential to end up in probate court. We still have potential privacy issues associated with probate and not having a proper estate plan in place. Also, you still have the possibility of losing control of your assets in terms of these assets not ultimately going to the person or persons you really wanted to be given to. You also have inheritance problems in that you have people who may inherit who you really didn't want them to inherit after all. And we'll show you how this plays out and how this happens. In sum, the consequences of joint ownership can include potentially disinheriting your loved ones, taking on the liability of others, and we'll go through this in more detail. And we also have the loss of your assets since others will be joint owners and the possibility of increased taxes as well. In this case, here you have a disinheritance situation playing out. Here, the disinheriting scenario is present both with the joint tenancy and with standard wills. Let's look at the scenario specifically where a joint tenancy arrangement goes terribly wrong. Husband and wife are happily married. However, wife passes away and the property is held in joint tenancy. So as soon as she passes away, the property passes by joint tenancy to the husband. The same thing would happen if the husband passed away and there was a will in place, as mentioned before. After a few years, he decides that he's going to remarry, and he marries this lady up here and decides that joint tenancy works so well when the first wife passed away that they do the same thing again. However, in this case, the husband passes away and the property goes to her. Being a good mother and looking after her children, she passes the property and assets to her own children, and, tragically, the original couple's children Now, when property is placed in a joint tenancy arrangement, there is also another more immediate concern, and that is the possibility that the original owner or owners will be subject to problems associated with liability from those added as joint tenants. Again, we have husband and wife passes away. Property from the wife transfers to the husband. This time, the husband does not remarry, as the love of his life is gone. So he decides that joint tenancy works so well with his wife that he is going to put his kids on the deed as joint tenants so that the property will automatically pass to his children. Well, at first glance, this sounds like a good idea as a possible estate planning solution. However, what can happen potentially is that now he and his property are liable for the debts of his children. If the children are liable for an accident, have a home foreclosure where they have a recourse loan, if they get into some credit card debt, or if they have a divorce potentially, a creditor can go after the property and force a sale to pay these debts. This can present a large problem and really disrupt families, as you can imagine. It sounds like a really good idea, but as you start to look down the chain of events, you realize the risk involved, all for the want of avoiding proper estate planning. Now, the same thing happens with the loss of control. This is the same scenario as above. Now what has happened is that all three of these people own the asset. It doesn't matter what the asset is. It can be a car, a house, or a bank account. Well, what if Dad wants to sell his asset? He can't sell his asset unless the kids sign off. Since the children are joint owners of the asset, they must all agree. If he wants to sell his home, he can't without their signatures. In a perfect world, there are no problems with families. In the real world, however, families move away from each other, families have agreements large and small, or maybe they have never gotten along to begin with. What about a reverse mortgage? First thing to do is that the kids would have to sign off, and now, unfortunately, the owners are all too young to meet the age requirements. They have to be over 62 to qualify, which is a requirement in federal law. Of course, people are always changing accounts if they have a certificate of deposit and would like to get a better rate. Unfortunately, they would need to also, as well, have their kids sign off on this transfer. There are also potential adverse tax consequences as well. If you change how the property is held from community property to joint tenancy with right of survivorship, you lose the double step-up in basis if one of the spouses passes away. With joint tenancy, you would only get a step-up in basis of the property on one half of the asset for the interest held by the first-to-die spouse, and then have to wait to get the step-up in basis when the second spouse passes. Unfortunately, because a proper estate plan is not in place, there could be a tremendous appreciation in the asset after the first spouse has passed, leaving the kids with a large capital gains tax to be paid after mother and father passed away. Since it's also a gift during life, a gift tax form should be filed if the transfer is above the annual exclusion amount for that year, to be applied against the lifetime gift tax exemption amount for the grantor. In closing, we see that doing nothing is not our best choice, and joint tenancy arrangements are not so great either. So what happens if we make a will? We will discuss these problems in our next meaningful estate planning video. We hope this brief overview of some of the consequences and pitfalls of joint tenancy has been helpful. If you live in California and have questions about the estate planning services we can provide, please call our office in Palm Desert at 760-777-0496 or visit www.hesseltinelaw.com.